everybody. My name is Jordan Walker. It is 5:30, and we are going to go ahead and get started. Thanks for joining me this afternoon to talk about the ComEd KARE project. I want to say that up front because we have a lot of webinars as part of our firm. We have a lot of webinars across the country. And we got a lot of reservations for this webinar. I just want to make sure that if you are here, you're here for the right webinar, and that is the ComEd KARE project. If you were here for an Ameren project or a road project or a project in Iowa or Missouri or some other state, this is not the right webinar for you. I just wanted to get that out of the way up top. And with that said, we're going to go ahead and get started. Forgive me one sec. There we go. Okay. So again, my name is Jordan Walker. I'm at the law firm of Seaver Walker Paget. I'm an attorney with that firm. That is our address, as our Illinois address right there. We are eminent domain only attorneys representing landowners. And tonight, this afternoon, I am here to talk about the KARE project, talk about eminent domain in the state of Illinois, and how to handle this process when ComEd comes in and starts making offers to you for your property. A little more background about our firm. Seaver Walker Paget is an eminent domain only law firm. We are an eminent domain only, landowner only law firm. So in other words, we only represent landowners, and we have historically only represented landowners facing eminent domain. It's the only area of law that we practice. It's the only area of law that I've ever practiced. And because we do this so much across the country, including in Illinois, we've learned quite a bit, especially about how to deal with utilities, how to deal with transmission lines, pipelines, et cetera, that are coming in wanting to acquire land for their project, whatever it may be. And because we've accrued so much information dealing with all of these cases, both Illinois and elsewhere, we'd like to share that information, share that experience with you, the landowner, and so that you are prepared here when ComEd starts contacting you about your land. That is our mission today, is to educate you, get you ready for this acquisition so that you hit the ground running when they come knocking. I want to stress and clarify that we are not with ComEd. We do not work for ComEd. We are, in fact, adversarial to ComEd. When a lot of people get our letters, they can't really make heads or tails of who we are, what we're doing, who we're representing. We are not here on behalf of ComEd. We are here on behalf of ourselves and here to help landowners out with their journey. Again, we're going to be talking about the project. We're going to be talking about eminent domain, and we're going to be sharing our knowledge. So let's talk about this project, because for some folks, this might be the first you're hearing about this project. It's called the KARE project, which stands for Kishwaukee Area Reliability Expansion Project. It's in DeKalb County, Illinois. It is a new 345 kV electric transmission line. It's 6 miles of new line. It is hard to tell by this map, but if you look closely, the route is this blue line right here. If you follow my mouse, it's right down these property lines, right there. That is the route of the project as we sit here today. There's also going to be a proposed substation up here. That's the yellow block right there. But the route of the power line will go north-south here along this line. The route of the project, this is largely the proposed route. You'll see right here, or maybe you will, maybe you won't see it. There's a little dash mark where the blue line kind of comes out a bit and then comes back in. So that is an alternative route. So just this little section right here, it looks like it's on County Highway 7 or Perry Road, is where it's possible that they could make a different route alteration. It looks like they would come up to the east a little bit and then come back to the west, or if you're going north or south, that would be the only route alternation, the only route alternative that's been proposed by ComEd to the ICC. Which brings me to my next point, how we found out about this and how we know what's going on. As part of any transmission line project in the state of Illinois, before it gets built, it needs to have approval from the Illinois Commerce Commission. That's the ICC. And in January, ComEd filed their application to build this project. If you're curious to find out more about this project, you can find every last fact you'd want to know by going to the ICC website, which is the link right here, and then going to this docket number. And this docket will detail the project. It'll show the petition, what they want to build. It'll detail the tower height, things of that nature, all sorts of facts about it. That'll give you every last detail about the project as we sit right here. As the project is situated, again, it is before the ICC. They just filed their petition in January. And we'll get into the timeline here in a bit, but if the ICC is going to be the source of most of your information for this project, the reason why you received a letter from us is because we looked at that docket and they identify landowners that are affected on this route. That's part of the certification process. And we took that list and we sent some letters out to folks informing them of the project and about this webinar. So that's how we got your information. It's all publicly available information. And again, you can check out that docket if you'd like to learn even more about this project, what's happening, and an expected timeline. Speaking of timelines, this is from ComEd's website. This is the timeline of the project. So last year they had some open houses, fairly common for them to do that. They filed their CPCN. That says Q3 2024. They were a little late on that. It was actually Q1 2024 or 2025 rather, Q1. Right now we are in obviously step number 3 based on the schedule. Q1 2025 to Q4 2025. That's the entirety of this year. I imagine it will probably bleed into next year as well, but that's their schedule right now. And that is preliminary engineering, design, and environmental surveys. So that would be, of course, if you have folks coming out talking about surveying on your property, that would not be surprised because that is part of the preliminary work that they do as part of the project's approval. As you can see, they expect their ICC approval before the year is out. I would say, given that they were late with the initial filing, that probably won't happen until 2026. And then the next step in all this is that the anticipated easement acquisition and permitting would take place. And that, according to their schedule, would happen at the end of this year and then into next year. Now, what we have found is that a lot of times these schedules are a little, they're either ambitious or they're a little not totally indicative of what's going to happen. I wouldn't be surprised to see them move up easement acquisition further in the year, further this year, such that you would receive an offer this year. Again, I don't know that for a fact. I don't work for them, of course. Just based on how a lot of these projects go, they usually like to start easement acquisition ahead of approval by the ICC. So again, that's my speculation. That's my educated guess. Regardless, at some point in the next year or two, ComEd's going to come to you wanting to acquire an easement on your property to build this line. Whether that is a month from now or a year from now, assuming the project goes forward, you can expect that coming at some point. So when they come to you and they make you an offer, they are going to want what's called an easement from you. And an easement, if you're not aware, a lot of people are, but some folks aren't. An easement is a grant of rights for something or somebody to be able to do something on an area of your property. It's effectively a deed, but instead of deeding the entirety of your property and your property rights to somebody else, you're selling only a portion of your land, and on that portion, only the right to do certain activities on that portion. Easements are fairly common in property ownership, whether it's a local distribution line easement that runs municipal water or sewer to your house, whether it's a driveway easement that allows your neighbor to use your driveway to access the road. These are all types of easements, and this is no different. It's just going to be a transmission line easement, and it should specifically allow ComEd the right to build and maintain a power line, a transmission line. Now, the biggest question I get from landowners when these offers are made and they get this packet of information with a bunch of legal documents on it, is will I be allowed to farm on it? Will they be allowed to do this? Will they be allowed to run pipelines? Will they be allowed to run fiber optic cable? Will I be allowed to run to let my animals out, my livestock out in the area? Are they going to have to build a fence? Do I have to build fencing? All of these questions depend on what the easement says. The easement is the most important document. It will define exactly what your rights are. It'll define exactly what their rights are. And it will be the document that governs any sort of dispute over whose rights are, who has what rights. So when people come to me and they say, will I be allowed to farm the easement? Will they be allowed to kick me off the easement and exclude me from it? My answer to that question is it all depends on what the easement says. And I'll say right now that, we haven't seen the easements on this project yet. I've seen a lot of easements from transmission line projects before. And a lot of times the easement that they present to landowners is not what they say it is. And a lot of times you are granting more rights in the easement than at first meets the eye. And we'll get into that in pitfalls, but I like to stress at the top of our presentation that the easement is going to be very important. It's going to be the most important document you sign. And regardless of what you do moving forward on this, it's very important that you make sure that document is carefully crafted. And the reason why is because easements are forever, especially these, well, I should say permanent easements are permanent. In some instances, there are temporary easements where the easements expire after a certain period of time. The area where they're going to want the transmission line, that will be a perpetual or a permanent easement. And what that means is that it will stay with the property forever, unless it is extinguished by the power line company at some point in the future, which again, they would only have to do if the easement required them to do so. But regardless, it is fair to assume that this easement will be a part of your property's title forever, which means if you sell the property, if your kids inherit the property, if your kids' kids inherit the property, no matter what, whoever takes this property, they're going to take it subject to this easement. It survives transfers. It basically sticks to the property unless it's specifically extinguished by the company. So the decisions you make today are going to affect the property forever. And the issue that we see a lot, especially on older easements on existing properties, is that these documents sometimes are very poorly crafted, very poorly worded. And a lot of times, again, as I stated previously, they will include rights within that easement, they being ComEd or whoever, Ameren, some utility, will include rights into the easement that are above and beyond what they actually need for the power line, because that makes the easement more valuable to them. Because they can sublease these rights, they can rent it out to other entities and make money off that when you don't make any. So these are some common issues with easements that we see, pitfalls, you could say. A lot of times, this is number one, and I see this almost on every easement, is that there is unfettered access language in the document, which means that in that easement document somewhere, there's a clause that allows them not only the right to access the property using the easement, using public roads, but also using other sides of the easement or any land adjacent to the easement. And reading that strictly means they could have access rights all over your property and not just to the easement. That is a common clause that needs to be removed. What that means is that even though they tell you they're going to use the public road to access the easement, they'll tell you that in person, but then when they actually need to go out there and start doing work on it, they can drive right through the middle of your crops, your fields, and drive over everything and cause all sorts of damage because the easement allows them that right. Again, that's the second point goes to the first. Access to the entire parcel, not just the easement area. I've seen issues where the language doesn't allow for future damages, crop damages in the future, or any damages that may occur in the future. I've seen situations where there's no clause for proper ground restoration and they have no requirement to construct the power line and undergo excuse me, undergo restoration requirements with the soil and the ground, such as segregating soil, keeping the top and the bottom subsoil separated, engaging in proper construction methods, getting rid of debris. All of these things you need to input into this agreement so that you make them do the things they need to do, or they're required to do the things they need to do. I've seen situations where they put liability on the landowner for issues with the power line down the road. So if, a tornado comes through and sends a pole flying out into the middle of your yard and kills somebody, there might be, unless there's language in that easement that specifically holds you harmless from these types of acts, you could be brought in on a civil lawsuit for something that's their fault. The right to build more power lines, sell their rights to pipelines, sell their rights to solar farms, sell their rights to wind turbines. This is the tip of the iceberg of the way these documents can be poorly worded. They'll try to get anything they can in there because, again, if they can sneak in, for example, the right to sublease your property to fiber optic cable companies, if they can get that accomplished and get that into the easement such that they can then do that without giving you any money for that sublease, then they're going to try to do it. It makes the easement a lot more valuable to them if they have that right. So I think a fair reminder to folks is that, if you're not sure, I guess, about the easement, it's as simple as shooting me an email, giving me a call, and asking me to look at it, which I will look at it for free and give you my thoughts. That's part of our job. That's part of what we do. I'm happy to review your offer and your easement when it comes and give you my thoughts on it and identify any problem areas if they exist. And, if they're an example of how things can get break bad in the worst way possible. There was a pipeline that went through Southern Illinois about 50 years ago. It was, I believe, the Sinclair Oil Company, which does not exist anymore, originally bought the rights to build that pipeline. And it was a significant pipeline. It stretched up into Iowa, into other states, but it went through the middle of Illinois, and we represented some landowners on the route. But the original easement was granted back in the 40s, up and down the line. And I'd seen a lot of them. They're very, very poorly drafted documents, very simplistic, de minimis amounts of money, very broad. And what they effectively were blanket easements. And blanket easements are easements that blanket the property, meaning they touch every four corners. They allow the owner of that easement the right to do basically whatever they want, wherever they want on the property. So what happened is on that project back in the 40s, these were signed. And then what happened is that easement was bought and sold and bought and sold and bought and sold. And then here, I think it was about 10 years ago, I was working on this project. We were representing folks that, as it turned out, the Sinclair Oil Company no longer exists, but guess who took its place? Enbridge, a large utility company, and they had ownership of these easement rights. They had bought them from whoever, and they wanted to put another pipeline right next to the one that existed and had been existing for 50, 60 years. And they did it, but they told the landowners, "We're not giving you anything else." And the landowners said, "Well, of course you are. You have one pipeline there. You want to add another one. You have to have the right to get the land to get to add the second one." And they told them to look at that easement. If you looked at that easement, those blanket easements that were signed 60 years ago, they had the right. They granted that pipeline company, which was Sinclair Oil Company then, which is now Enbridge. And they gave them the right to add 1, 2, 3, 4, 5, 6, as many pipelines as they want, wherever they want, whenever they want, without further compensation owed to the landowner. That is the worst case scenario. That is signing that, for peanuts, and it sticks with the property. And then here we are 60, 70 years later, and the current landowner of the property is getting the shaft because of an easement that their grandparents or great-grandparents signed so long ago. So, of course, this is now looking towards the future, but it's just important. It's, in fact, imperative for you as a landowner to make sure that that easement is properly drafted, that it includes the protections it should include, and that you're granted the right to use the property to the full extent that you can. So that's the first portion of your case when ComEd comes in. There's two portions of every landowner's eminent domain utility case. The first step is the easement. And the second part of your case is the money. Because just as they can offer a bad easement, they can offer a low compensation figure. In fact, they're fairly common for utilities to lowball folks when they come in and make these offers. So I'll just say what your complete compensation package should include all these things. So a complete compensation package for your easement should include all these things. It should include a proper price per acre for the land that's going to be acquired, a proper payment for crop damages up to 5 years, if possibly more. Either prepayment for anticipated soil ground damages or a clause requiring them to remediate. Remediation of land after construction is a big deal, especially with these types of construction projects. There's going to be some big trucks, big heavy construction equipment. It's going to be running over your property, and especially for agricultural property, it's imperative that ground is sufficiently repaired, or it could be permanently affected. And I've been a part of cases where utility projects come in and they say they're going to do one thing, and then their contractors get on the ground and they go roughshod. So it's up to you to either get that money up front or implement some very, very strong, stringent easement language that requires them to properly remediate the ground. So beyond that, again, proper consideration of all damages such they exist or may exist, field tile, irrigation, compaction, all of the issues that can affect good agricultural land, they need to be considered. Any possible damage, if you have livestock, if you have fencing, anything like that, timber, for example, there needs to be consideration of timber damages as well. And this is in addition to anything that's offered by the ITC, ComEd. Got the wrong utilities in my mind. Sorry. We got a lot of projects going on. Apologies. Yeah, this is in addition to what ComEd will offer. So it should include all of these items if you want to get a proper consideration. And I will say, beyond that, actually, in addition to all this, you need to make sure that your compensation package includes any impact that the power line, the transmission line has on the rest of the parcel's value. So if you have a 40-acre tract and they're running this thing right through the middle of it, where you previously didn't have a power line, how does that power line not only affect the ground that it's occupying, but how does the introduction of that power line affect the entirety of the parcel? What does a 40-acre tract untouched by a transmission line sell for versus a 40-acre tract that does have a transmission line? And what does that sell for? What's the difference between the two properties? The difference between the two properties is what you are entitled to, and that is any diminution in value that the transmission line causes to the rest of your parcel. So it's not necessarily just about what they're taking, it's about what they're leaving behind. How does this transmission line affect all of your property's value, not just the area that they're going to be encumbering? You are entitled to that, and it's something that rarely is brought up. And it's not brought up by land agents, right-of-way agents. These are the folks that will be coming out and providing those offers to you when they're ready to acquire the property. So their job is to come out and sell you on the idea of you selling them your land for this project, which means they've developed quite a few tricks, strategies that they've implemented to try to get folks to sell them their property. And these are just some examples of some tricks we've seen. We've seen them say they're going to offer more than fair market value, that they're going to offer bonus payments. If you sign now, they'll offer crop damages as if they didn't already owe you these crop damages before they even got started. If somebody knocks down your crops, they have to pay for it. they like to have a shell game where they have, they want you to quibble over price per acre, and say, well, if they come to you and offer you 17 an acre, you think it's worth 19 or 18 or 20, they want you to get in that argument over price per acre, because talking about 19 an acre, 20 an acre on a 3 acre acquisition isn't significant money. It's $3,000. But if you're talking about remainder damage, for example, how does this power line affect the rest of the parcel? Those numbers escalate quite a bit more. A 10% impact on a 40-acre tract that's worth $20,000 an acre is $80,000. Do you want to quibble over $3,000 price per acre or $80,000 on remainder damage? This is the shell game they play. They want you distracted with things that they want you to talk about and not what they don't want you to talk about, which is construction damages, diminution in value, all the things where the big money resides, the categories, the topics of damages. We see a lot of verbal offers. We see lowering offers, raising offers. What I tell people when they begin to have their discussions with the right-of-way agent is I tell them not to have the discussions. I tell them, do everything via email. Say, if you want to give me an offer, you can send me an email and you can send me the offer via email. I tell folks, avoid in-person discussions, avoid having these verbal conversations with right-of-way agents, because verbal promises mean nothing. If they want to promise you something, whether it's money or language, they should put it in writing. And the easiest way to do that is to have them converse with you via email, via text, where there's a record that you can refer to. What I tell people is when they start talking about making offers, they're going to want to do it in person, and most likely they're going to want to sit down at your dinner table and your living room and be your best friend and sell you on this packet of documents they're about to give you. That's what they want to do. What you should do is when they give you notice that they're going to come give you that offer, say, we don't need to meet. You can send me the offer via email, and I'll be in touch in a week. And that'll allow you to then use that offer to go out, talk to attorneys, talk to people, get a second set of eyes on it, to look at it, and then respond in turn at your pace, not being hurried or rushed into a decision in your living room by a right-of-way agent. Ultimately, if you aren't sure about that offer, about it's good or bad or what, again, contact me, send it to me. I'll look at it for free and I'll give you my thoughts. And I am approaching the end of my presentation. I do want to talk a little bit about how our firm works. If you were eventually interested in hiring our firm for your case, I should state that our firm's representation is twofold. It is easement and money. We will help negotiate your easement. We will help you negotiate your money, and our fee is paid out of how much more money we get than what is offered by ComEd. An easy example right here is if you're offered $10,000, we get you $50,000. In that scenario, we add 40, we collect a third of that 40, you get the rest. We do it this way first of all, it's easier for usually all the parties. Second of all, you can trust that I'm looking out for your best interest, because this contract puts us in the same boat. We are after the same thing together, and that's trying to get the best deal possible. We also understand that nobody wants to come out of pocket to hire an attorney for something they didn't ask for. And this allows you to hire me without having to come out of pocket. Our fee comes out at the end. You don't write the checks. We do at the end of the case, and then that's that. We do have hourly. We do a traditional attorney billable rate for some folks if they're interested. If you're interested in an hourly or a flat rate, we can talk about that individually. So I want to talk about moving forward and next steps. So knowing what we know about this project, we were at the very beginning of the process. So I want to say that. I don't think anyone has offers, or I didn't see anybody with offers. I could be wrong. But most of the people that signed up for this did not have offers yet, which is to be expected. It is not a huge project, but it definitely is an impactful project. I would expect, again, that you're going to get an offer in the next year. But again, it's hard to tell with these things. They're very hard to nail down. But you're ahead of the curve just being at this webinar. You've already, you already have learned more than your neighbors, and you are prepared for when they come in. Moving forward, when the offers start getting made, as soon as you receive it, you should hire an attorney. If you have existing easements on your property, if you have an existing power line easement on your property or a gas pipeline or something like that, I would take a look at it, see what it says. I think that could prepare you for, what Ameren might potentially try to do down the road. If you don't have a copy of the easement, I would go to the county recorder's office, the county deeds office, and request any easements on your property. They should be able to do it pretty easily. They'll either do it over the phone, or you might have to go in person. Develop a plan, develop a strategy for what you want to accomplish, how you want this to go. If you can create a group of landowners, that can be very beneficial to you. If you come to me and say, Jordan, it's me and 10 of my neighbors, that will, the name of the game is leverage in these negotiations. And how do you as a landowner get that leverage against ComEd? And one of the ways to do that, one of the ways to do it, the easiest way to do it is hire an attorney. The second easiest way to do it is to form a group of landowners that are also represented by the same attorney. That allows, if I go to ComEd, for example, and I say, hey, I got 5 folks on this line, let's start talking. They're going to respect what we want, of course. But if I go to them and say, listen, I got 20 folks, I got 30 folks, and we represent them all, then that leverage can be felt by everybody. The more power I have, the more leverage all of my clients have. So everyone still has their own individual case, of course, but the threat of a large group of landowners, fighting for what they want, can oftentimes result in better results for everybody individually. So if you can form a group, that's great. If you can't, it's not a problem. Just something to consider since we have some time before offers come out, assuming we do have some time before offers come out. Again, and this is my final point, and then I'll open the floor for questions. If you have questions, feel free to put them in the chat or the Q&A button there at the bottom of your bottom of the page. Feel free to get those questions in now while I'm talking, if you could, and we'll address them once I'm done. We already talked about how important groups are. If you have questions about the project or about eminent domain or anything like that, you can send me an email, shoot me a call. I'm happy to answer any questions you might have about this project, about eminent domain, and about what to do when the utility wants your property. If you have an offer, when you get an offer, of course, you can just send it to me at that email address. You can text it to my cell phone. You can fax it to our fax number, whatever is easiest for you to get that over to me. And then I will look at it, again, for free. And then I'll get back in touch with you and give you my thoughts, and you can decide what you want to do. So with that being said, that is the end of my presentation. I'm going to open this for questions if there are any. And yeah, so if you have any questions, please ask them now. Hey, I'm not seeing any questions. Okay, easy enough. Well, if there are no questions, and that's fine if you want to ask them later, if you want to send me an email separate, if you want to talk outside of the group, that's fine too. But yeah, don't hesitate to shoot me any questions you have or your offer. I'm happy to look at it. Otherwise, thanks for stopping by. Good luck, and we'll be in touch.